My name is Una Cho. I'm a New York qualified lawyer at the law firm of Kim and John. I'll be your host and moderator today. I hope you've all been enjoying the conference so far. We welcome you. We're very glad to see you here today because we have a very ambitious program with a wonderful panel of speakers today. Today we're going to start from the beginning, cover the sort of the basics of arbitration, the concepts of technology disputes so that everyone's on the same page, and then move on to discuss the recent developments, the fast-moving developments in technology and how those disputes are changing the practice of arbitration. So before we get started, I'd like to first invite our program chair, Ms. Kyung-hwa Chung, who organized this event, to say a few welcoming words. Ms. Kyung-hwa Chung is sitting on the far right, and she's the Of Counsel and International Arbitration Practice Group of Covington and Burling LLP based in Seoul. She represents both state and corporate clients in complex international disputes. She has represented clients under various arbitral institutions, including the ICCCI, HKIC, ICSID, KCV, and her practice includes disputes arising in energy, construction, technology, life sciences, finance, agro-industry, defense, mergers and acquisition, and as you can tell, she's a very experienced counsel, and she's done a lot to make this a program, a fruitful program for everyone. So, Ms. Kyung-hwa, could you say a couple of words?
Thank you, Una. Thank you for that kind introduction. Hello, nice to meet you, everyone. Good morning. Hope you had nice sleep last night. I'm Kyung-hwa Chung. I'm an of counsel at International Arbitration Practice Group of Covington and Burling. I spent some years in Washington, D.C., New York, back in Seoul. Good to be here after all that COVID years in New York. I'll be quite informal because I know there are many more experienced practitioners here who have great insight into this very topic, who can share their experiences and also their views on this, sort of novel issues in technology. So when Iwa, who's the organizer of the ABA conference in Seoul, asked me to put together a panel on international arbitration, she asked me to choose any topic that could be related to technology disputes. So I was giving some thoughts on this issue, and I thought maybe let's talk about commercial arbitration and how both commercial arbitration and investment arbitrations are used by tech companies to resolve their issues. We know tech impacts a lot of our daily lives. Everybody is looking at their tech devices at the moment right now, either that's mobile or their laptop. It's affecting our daily lives every day, but we don't see in terms of commercial arbitration, we don't see that many arbitration cases related to tech disputes. So I was just wondering whether arbitration, is it suitable for tech disputes or is it not? Why is it underutilized as opposed to litigation? And what's the very reason behind it? And what about investment arbitration? What's the emerging trends in investment arbitration? Because as we'll be discussing some of the statistics that's been released by the ICSID, we see that there are a lot of tech-related disputes arising from this very industry. And is there sort of a general trend behind it? And what are some of the unique features that are related to the unique characteristics of technology disputes? That's some of the issues that we want to delve into during this 75 minutes. We have invited in-house counsel who has great experience. Una will be giving more introduction to it, but we have a very diverse panel today to give their own views on these issues. And I would really want you to also participate in sharing your views and in other parts of the world. Thank you.
Thank you, Ms. Chung. She'll also be part of the panel of speakers, and I should mention that she and I and a couple of our audience members are part of the PCAB's Women in Interest Committee, WIC, and we thank WIC for its support for organizing all these events. Now, we've organized today's session into two sections. We'll first address the technology disputes in the context of commercial arbitration between private parties, mainly contract disputes. Then to reflect how the changing national legislations and outlooks related to technology has impacted on the arbitration field. We'll also discuss how these developments are impacting on treaty-based claims, mainly investor-state disputes, ISDS. For the first session on the commercial arbitrations, our speakers will be Mr. Y.S. Young-Suk Park and Ms. Ye-ji Kim. Mr. Young-Suk Y.S. Park right now leads the Shin and Kim's international arbitration practice. Those of you reading on the written material might find that it's a little bit outdated because he has recently moved from KL Partners arbitration practice, so he's become even more important during this short period of time, so you might all want to grab his business card before you leave. Before that, he used to be at Kim & Chung, so he was my former colleague as well. And aside from all these law firm arbitration practice, he's also served as the executive director of Aetnam Partners, as well as general counsel there, which is a major investment house in Korea. And he's also acted as a statutory auditor for Aetnam Investment, a publicly listed venture capital investment subsidiary of Aetnam Partners. He's also very active in the arbitration practice in Korea. He's on the panel of arbitrators for KCB and also is a member of the management committee for the Korea Council for International Arbitration, KUSIA, as well as the management committee of the Seoul International Dispute Resolution, SIDRC. Now, seated next to him, we're also very lucky to get Ms. Ye-ji Kim to be our panel. She is the legal counsel at Oracle, Korea, based in South Korea. And before that, she was an in-house counsel at WeMade, an online gaming company, where she contributed to the international commercial arbitration proceedings, particularly focusing on MMORPG intellectual property disputes and contract disputes. She has a lot of experience in IT commercial transactions, as well as international arbitration regarding these IT issues. And she has also experience in litigation cases related to cryptocurrency delisting and blockchain platform link issues. She's also worked for the Ministry of Justice involving ICSID cases. So after these two panelists discuss the commercial arbitration, we'll move on to the second session discussing the investor-state disputes, and that will be covered by Ms. Chung as well as Mr. Bart Waziak, who is a senior associate Arnold and Porter based in London, and we also have a very important person because he's also the co-chair of the ABA International Arbitration Committee, and also the associate practitioner at the University of Nottingham Commercial Law Center. Mr. Waziak's practice focuses on representing sovereign state and private sector clients in high-stakes international arbitration proceedings, and he has to date served as counsel in more than 20 investment treaty arbitrations under the ICSID and UNCITRAL arbitration rules, and he frequently speaks and writes on international law subjects and is recognized for his expertise in public international law as well as international arbitration. So once we discuss the investment state arbitration session, we will save some time for questioning from all of the panels. But since we have, I think the advantage of having a smaller group is we can have an interactive session. So if anyone from the audience have questions, please do not hesitate to raise your hand, and we can put them on the stand and see how well they do. Okay? All right. Without further ado, we will then move on to the commercial section, and I'll hand it over to Mr. Park, and I am operating. This is why I'm not on the panel. I don't have technology. Okay.
Hello everyone, thank you for your time today. It is a pleasure to speak to you all together with Yeji. In fact, for our section, I think Yeji will have much more insightful comment on this issue. Since as you can already see, Yeji has a nice tablet, I am very traditional with paper, so I'm not very tech savvy. And I read today's an article which was talking about AI in arbitration, although today we are not going to talk about that, but that article said while AI will not take over lawyers, lawyers who are familiar with AI will take over lawyers who are not familiar with AI. And I'm seeing myself being taken over. So, what is a commercial technology dispute and what makes it unique compared to other disputes? In the traditional sense, this discussion has mainly focused, I think, on IP disputes. And usually, when the issue of IP disputes came up, what is usually discussed together with that is whether IP disputes are arbitrable. And that is because arbitration, at least in the commercial sense, a commercial arbitration requires the agreement of the parties. And in the next sense, the IP disputes involve the relevant local authorities and local authorities with regard to registrations, licensing, and so forth of the IP rights, which makes it a bit difficult for a party to commercially arbitrate IP disputes to the fullest extent. And hence these discussions as to technology disputes and arbitration, I think traditionally were focused on this part. Now, because traditionally that was the sense, and because of this, various jurisdictions have tried to implement legislatures to promote arbitration in these sectors. For example, even the Korean Arbitration Act was amended. It sounds natural, but was amended to include that commercial arbitration would also cover non-property disputes, which is interpreted as including IP-related disputes. But Korea has not taken it further, for example, like in Hong Kong, where Hong Kong has made it clear that IP disputes are indeed arbitrable. And in that sense, the IP disputes and arbitrations are a bit, the nature of disputes are not as unique as you would see, you would think. So usually in commercial arbitration, what you see is, in regard to commercial technology disputes, is what is actually a contractual dispute. So you have a contract, a licensing agreement, for example, and certain disputes arise from that arrangement. So it could be IP infringement, in the sense that the license was being overstepped, non-payment issues of royalties, non-compliance with information requests that is usually required under these sort of private arrangements, and then maybe issues of fraud. And I know I'm just listing it up, but Yeji will have much more interesting comments on this. However, there are certain unique aspects of commercial technology disputes, and they arise because the technology itself is becoming more complex and covering various platforms. And therefore, the contracts that are involved in that require a certain additional interpretation to cover these developments. Also, for arbitration and technology disputes, damages are being approached a little bit different from traditional court proceedings, at least in Korea. And Yeji will have very good war story on that. And then, of course, what is usually discussed when you're talking about arbitration being superior to a traditional court proceeding is the interdisciplinary expertise that is required because, of course, court judges, even though you may have specialist judges in IP and so forth, still the technology expertise are a bit different in the sense that in arbitration you can choose your arbitrator who is more experienced in that. And then certain IP or technology related contracts by themselves have a very unique relationship, and we will go into that a bit further. And finally, as mentioned, you're seeing more and more different technological platforms, which then translate into different types of disputes. And I will now give the floor to Yeji to provide further.
Okay, thank you, YS, for the great introduction. And so I do have some experience in arbitration, but I'm not an arbitration lawyer, and I'm just a Korean lawyer, and I would like to ask for your understanding for my English. And that said, by YS, I want to share my experience as an in-house counsel. I have dealt with about 5 international arbitrations regarding the same IP license agreement. So my story would be limited to that experience. So I would just like to put a disclaimer on that. And just like I said, I think as an in-house counsel, I think commercial technology disputes are not as too unique in the sense that they all stem from contractual breaches, from my experience. And I think it's probably because companies have embraced these new technologies and new platforms to their traditional business models. And when disputes do arise, we only have conventional legal frameworks to actually apply and to resolve the matter. So I think the distinctiveness and uniqueness becomes evident in the process of these proceedings in interpretation of how are we going to interpret these new technologies with our tools, with our old tools, and these new elements on the way of resolving the dispute, how we are going to interpret these new elements in the framework of old traditional legal arbitration or dispute resolving methods. So just to provide you with a rough example of my experience, say, think of an online gaming company who developed a massively successful PC client game in early 2000. I don't know if you guys would know what PC client game, I think Mark knows. So at early 2000s, you had to have a CD, and you had to put in a CD-ROM in your computer and install to play what we call MMORPG games these days, like Legend of Leagues and WoW. So my company had developed a massively successful game in the 2000, early 2000, and the company has granted its IP license to another company in another jurisdiction, which was PRC, and under the name of license agreement. And the agreement actually stipulated that the license would be limited to the PC client games only. However, as times have passed, the success remained in that jurisdiction, not in Korea, but in China, the popularity remained, and the licensee company began to develop web games, HTML5 games, mobile games, even blockchain games, because of the development and advancement of the technologies and emerging platforms. So they were arguing upon arbitration, they were arguing that this is not a breach of license agreement, because at the time of the execution of the agreement, there were only PC client gaming platforms available. And in that sense, they have to interpret these licenses to be available for all the platforms at the time. And so there was this huge legal question whether this was a breach of a contract. And say, and if the scenario goes on, if this is all developed on a blockchain platform and issues a cryptocurrency coin, would that be an actual revenue that the licensor can claim its royalty on? And if arbitration is initiated, and for blockchain there is no centralized entity, they say. So if the foundation says we are not in control of this company, we are not making any revenues, we're just making this an ecosystem for all the coin holders, then in this case, how are we to decide what jurisdiction the defendant is allocated? So in conclusion, the arbitration in Singapore actually denied the argument of the defendant, and the claimant was able to be awarded with I think $800 million for the liquidated damages. But I think it's so this was I think kind of landmark decision in IP arbitration, in my opinion. So quantum jurisdiction, interpretation of contracts, finding of evidence, all these conventional legal frameworks are now being challenged, I think, and the complexities are amplified and in finding consensual ground for tribunal, the councils, and the parties. I think I'm talking too long, so can I just ask a question? In that case, did the defendant pay any royalties for the other platform revenues? No, it makes sense. So that was the claimant's claim. If this is not breach, you should at least pay the royalties. But so there were many contracting costs. So to summarize, I think my example kind of sums up this uniqueness of technology, that damages are really scalable. It means that damage really snowballs in rapid time and short time of being, because so many multiple platforms, the technology that can duplicate any source code, license, these programs are now so advanced, it can just move across borders so fast. And along with that, it's becoming more and more difficult to breach these detections because they're so intricate. And if there's no cooperation from the defendant's side, it's almost impossible to actually detect what is going on in the very beginning. And so, with the arbitrariness of conventional laws applicability and blurriness in interpretation and understanding of contract terms for the technology and platforms.
Not at all, and I think Yeji has not done justice to the complexity of that particular case, because it was not a simple singular contract. It involved actually multiple contracts and multiple licensees, and then also multiple, by multiple I mean literally a few hundred, breaching parties who infringed on this IP, but were not only being prosecuted under the relevant IP regulations and law, but with regard to the contractual relationship that was being established by the network of license and license agreements. In the similar sense, before I move on to the next page, from a commercial, at least at the moment, from a commercial technology dispute perspective, arbitration in this sense can be very attractive because it may provide a sort of one-stop resolution option, although there is some fine-tuning to occur. For example, one of our clients has a licensing arrangement with there are two global entities, and they have each other's licensing arrangements, but at the same time they also have a separate development arrangement, and on top of that they have a global distributorship arrangement. And the global distributorship arrangement, of course, is not a master agreement, but it is, for example, a distributorship arrangement per jurisdictions all over the world. Now, in that particular issue, an issue arose with regard to the development arrangement, but of course, because of that, it has a snowballing effect on all of the other arrangements, which include various jurisdictions. Now the issue has become whether this may be resolved under one arbitration. All of these contracts may be resolved under one arbitration, which may provide a fairly efficient resolution. Otherwise, you would have to go through the courts in various jurisdictions. resolve that. And in that sense, technology disputes which have these, or which may have these far reaches globally, can benefit from an arbitration dispute resolution mechanism. And I segue into the next slide. Oh, it's already there. Now, I think most of who are sitting here are familiar with arbitration, so this is more of a fairly general introduction of what are aspects in arbitration, a bit categorized in more detail to explain the next issues that are mainly related to technology disputes. However, as everyone knows, commercial arbitration needs an arbitration agreement between the parties. Now, of course, there in IP disputes, there are certain other venues available, for example, right to split office, where there's no arbitration agreement, and you apply to the WIPO to initiate mediations or arbitrations, and then maybe post-contractual arbitration agreements can be reached. However, in principle, you need an arbitration agreement. And then, of course, you have the tribunal, which is an important factor in arbitration, because you get to choose, or not choose, you get to have a certain say as to how you want this tribunal to be constituted, which basically means you get to have a say as to who's going to be your judge, which is a fairly interesting factor for technology-related disputes, because, as mentioned, you may want someone with certain expertise to be sitting over your case. And then the third point is arbitration is not a fixed process. It's not a fixed process in the sense that the court decides, has already a procedural rules in place. Of course, arbitration institutes have certain procedural rules, but as you know, they are fairly broad and leaving a lot of leeway to the tribunal and the parties. And the tribunal, again, in practice, gives a lot of leeway to the parties. Which makes it interesting because then if the dispute is more complex or has certain aspects that are very unique, then the parties may be able to reach an agreement as to address these complexities via a procedural process. For example, bifurcating it, having separate expert meetings or joint reports, or trying to put in certain procedures that evaluate the technology and so forth. And then, of course, the other aspects in arbitrations, which are usually for in-house counsel, interesting, and also for the law firms, from the counterparty perspective, are costs. And in Korea, while costs in court proceedings can be awarded, they are based on a formula, so you will not get your actual costs. It may be different in other jurisdictions. However, in arbitration, in commercial arbitration, it is the general rule that the costs, your actual costs, will be part of a cost award and may be awarded to the other side if you prevail in the dispute, which makes an arbitration, at the end of the day, may make it quite attractive for a party who is willing to pay for it, but also wants to recoup the cost that it can spend. And then, of course, you have the more traditional aspects of confidentiality, enforceability, and so forth, and I will not go into these, which are different from court proceedings in the sense arbitration is confidential and enforcement is done under the New York Convention, so you have the option of global enforceability. Next slide, please. So, what among these factors that we've mentioned, what aspects make arbitration attractive for technology disputes? And the first point I would like to go into is parties' autonomy and flexibility. I think, again, Meiji has the more important piece.
Thank you for that. So as for in-house counsel and speaking from companies, so I think autonomy and flexibility is one of the biggest factors that we consider beneficial in initiating arbitration. So I want to share another experience, is that we had another international commercial arbitration case with another Chinese company regarding the same IP license, because it was really big and popular in China. And this is a case where defendant licensee company was allegedly non-payment as well as manipulation of its revenues and sales data to falsify the royalty due payable. So defendant had reduced their revenue and sales figure down to 1/3 of what it actually really we thought it were. So they have been distorting monthly sales number and KPI report dashboard in digital program that the both parties had agreed to take a look at it in every month. So my company suspected manipulation through our audit and internal market estimation analysis. And of course, upon allegation, the defendant refused to submit any evidence, and no significant document production was made to the tribunal. So my company, our counsels, filed an application for assistance in taking evidence on which the tribunal ordered defendant's document production. And again, defendants refused to provide any meaningful document except for a few lines of source code of their game, claiming that this is not your game. This is not the game that we use your IP license and your source code. So but the problem here was there was no third-party expert. Your tribunal could not actually decode or analyze these source code provided by the defendant. So what we had to do was we had to find a developer and expert engineer in our own company to actually decode what this source code actually meant. And so in the end, the tribunal decided that the defendant failed to provide necessary requested evidence, and to our surprise, the tribunal's adverse inference was made, awarding claimant with $70 million for full damages. And the tribunal here clearly stated that the defendant should not be rewarded for its failure to cooperate to provide reasonable information within its possession. So I think this case was meaningful in terms of our discussion today, in that the tribunal has clearly shown the way how damages can be assessed when there's no material evidence and in case where everything is digitalized and when an actual manipulation is suspected. And how counsels and claimants, or in another case, defendants can utilize evidence preservation measures and eventually draw an adverse inference decision. So I am not an expert, but I've heard that this is not a usual case that usually happens. So I think this nicely sums up the benefits that we could use as an arbitration, because for Korean courts, in order to have the damages awarded, we must prove that the damages have been crystally materialized. So if we brought this allegation to Korean courts, we would not have been able to retrieve $70 million because there was no way to prove that the damage has actually happened. So I think this just kind of summarizes the beneficiality of arbitration, that the autonomy and the tribunal, use of experts, and actually the discretion that the tribunal has in deciding what evidence and how this evidence they should take into account.
Yes, Yeji brings up a good point, which is different from Korean court procedures, which follow this in general civil law jurisdictions. It may be different from many of you in the city of common law jurisdictions, such as the US, and are more familiar with heavy or high awards. Like a better term. So yes, in Korea, I mean, usually we don't have a discovery process. it is provided formalistically under relevant laws, but it's not being practiced in the sense of what you would experience in common law jurisdictions, in particular in the US. In that sense, arbitration, international arbitration for commercial disputes provides a production process that is a bit broader than what you would see in local courts, which then also translates into your ability to better present your case. Damages, of course, in this case, the damages did not, the document production did not help the damages. However, then, as mentioned, for example, in Korean court proceedings, even if you had an expert available who would, evaluation expert, difficult for the court to accept such expert testimony as is, and usually the court by itself would apply a certain discretion as to quantification of damages, which it has under law. And because they're judges, the discretion usually applied is not based on from a corporate level, but more from an individual level, where traditional disputes, arise, so you get a bit of a lower award in that sense. I think we're running a little bit out of time, but I wanted to ask Yeji as to 3 points which are usually mentioned as benefits of arbitration, which are cost, confidentiality, and enforceability. And I wanted to ask Yeji, whether from an in-house counsel perspective, whether she really felt these benefits, or whether they are maybe overstated or have some nuances that we are not aware of.
Yes, yes, these 3 elements are usually what the reason that we choose arbitration. And I want to point out that confidentiality was the important factor for our side, but as it was important to bring the other party to the table, because the Chinese company did not want to cooperate in any litigation that goes on in Korean jurisdiction. And for the claims, we do not want to go to Chinese jurisdiction. So, with all these IP licensing, the tech companies, of course, other companies I think as well, but do not want to share their business structure, their business models, and so the confidentiality has been a core aspect in choosing the arbitration. But however, with cost and enforceability in practice, I think corporates used to believe before arbitration, used to believe that this could be a real benefit because you can retrieve the cost once you have won the award. And usually companies do believe that they are the ones who's going to win. However, we've experienced that that's not always the case. We still, my previous company still has a couple awards that has not been able to be enforced in another jurisdiction. So I think it could, in practical level, I think it's good for companies that you get informed of this in the initial stage, because it comes as a surprise, because you would think that enforcement would be easy, and companies usually forget the tribunal is not a national court that can have enforcement, that does have enforcement power. So in that regard, I think, but however, I think benefits are much larger, especially in technology disputes, and for arbitration rather than litigation, especially in Korea.
And I will take 30 seconds to close off this session. So what may be considered commercial arbitration to be further utilized for technology disputes? And there are many more aspects, but maybe not going into a slide, I'd love to mention. As most of you here may be familiar, the WIPO cases for mediation arbitration have drastically risen in 2022. We don't have data for 2023. It's almost double, more than double compared to 2021, which showed a steady increase, but then drastically increased And one of the aspects I believe that make our WIPO attractive is that WIPO promotes mediation. And so if you look at the WIPO cases, many of the cases in mediation arbitration, around 70% I believe, are being settled, which provides a fairly quick, fairly robust and swift resolution mechanism, because if it's settled, it means you don't have to worry about enforcement, additional level to the dispute. And in that sense, I believe that arbitration will have fairly significant benefit for technology-related disputes in that regard. The points that are on the slides are more how to make arbitration easier in IP disputes. In that sense, if it makes it easier, then it also increases the possibility of the potential settlement, because the parties in there will see, oh, I will get to a certain point in time. And you see it's joined up, so multiple parties or multiple contracts, emergency measures, because usually in arbitration, emergency measures are not enforceable in many jurisdictions, so laws need to be implemented that allow for that. And then, of course, we have the issue of enforceability, which is one aspect that still needs a lot of gymnastics, because many technology disputes may require the assistance of local authorities via registrations and permits and so forth. And I end on that note. I think I've overrun it a bit.
Thank you, Elias, and thank you, Yeji. We think it was a very helpful session to sort of lay the ground. Can we maybe, because we're a little bit behind, save the questions for at the end? Yeah. Yeah.
I don't forget the question, but that's fine.
I'll come back to you. Continue nothing here. So I think it was helpful to lay the ground and understand how a real life case works in a company. I think now we'll move on to how these changes have impacted on the national legislation regarding technology and and how that in turn has affected the treaty arbitration claims. So let me put up the next slides. Good. So we'll hand the mic to Barb and Dongha.
Thank you, Anna. Good morning, everyone. Great to be here. So we wanted to start the second part of the session with a little bit of a primer on investment arbitration. Investment arbitration is something that I do daily, but I'm conscious that it's a little bit of a niche, and not everyone is familiar with investment arbitration, so we wanted to start there. So in a kind of a 1-minute summary, investment arbitration involves disputes between investors, and specifically foreign investors foreign to a particular state, and the state in which they have invested. And the subject matter of these disputes is the state's compliance with investment treaties, and these can be bilateral investment treaties or multilateral investment treaties. And there are now roughly 2,600 these kinds of international agreements in force around the world. And then on the right side of the slide, you can see some of the fora in which these cases are heard. I should say that there is a related term, investor-state dispute settlements, ISDS, which also encompasses contract-based arbitrations against states, and also arbitrations initiated pursuant to domestic laws on the protection of foreign investments. So all of that together is what we refer to as ISDS. Thank you. So on this slide, we just listed some of the substantive standards of protection that you will typically find in an investment treaty. Unfortunately, I don't have time to discuss them in detail, but just to note that they include things like protection against unlawful expropriation, and also something called fair and equitable treatment standard, which is a very broad and perhaps vague standard, but it includes, among other things, the protection against, or the protection of the investors' legitimate expectations. and that's an issue that often comes up in these cases. And then on the next slide, we've listed three of the jurisdictional requirements that often investors have to satisfy. So in order to be able to claim protection under investment treaties, investors or an investor has to prove that the case, that it as an investor in the case, the dispute falls within the scope of the relevant treaty, which is what we refer to as jurisdiction. And the list on the slide is by no means comprehensive, but it includes just three of the items that typically come up. The first one is kind of obvious, which is that the investor, the claimant must be a foreign investor, and that often is seemingly should be a simple thing to prove. It's essentially about proving the nationality of the investor. But I'll come back to this. The issue may become more complicated in some tech disputes. The second requirement that we've listed is that the claim must relate to a protected investment, investment as it is defined in the treaty. And that's often a very contentious issue in investment treaty arbitration. These treaties often include fairly broad definition of investment. Often it will say something like that an investment is any kind of or every kind of an asset invested by an investor in the host state. But again, I'll come back to this in a second. There may be questions as to whether something actually qualifies as an asset for these purposes. And then the third requirement listed there is that the investment must be in the territory of the respondent state, which again seems like an obvious kind of criterion since we're talking about the protection of foreign investments, but again, that could lead to some issues. And so underneath each of those boxes, I've listed some issues or some questions that could come up in technology-related arbitrations. Unfortunately, I don't think I'll have the time to, at least for now, to cover them in any detail, but just to illustrate, with respect to the first requirement, one can wonder whether a company that claims to be stateless, and there have been some technology companies that have been almost as a marketing strategy saying that they're not really bound to any particular state and they operate, globally and they claim to be decentralized. Could such a company bring an investment treaty case? I won't answer this question for now, but it seems like an interesting question. The second issue that I've listed there relating to the requirement that the claim must relate to an investment is whether data could qualify as an asset and therefore as an investment. Obviously, data can be hugely valuable for technology companies in particular, but investment treaties typically, most of them were signed at a time when that wasn't the case, when data wasn't something that people considered a significant investment. And so investment treaties don't typically deal with this issue of whether data qualifies or can qualify as an investment. And then thirdly, briefly, with respect to the requirement that an investment be made in the territory of the respondent state, for technology companies there may be an issue as to whether a digital business can be said to have made an investment in the territory of the state if it's a business or service that's really delivered mostly online. So those are just some of the, I think, relatively interesting questions that could come up in these tech cases. But as we will see, there have not been actually that many yet technology-related ISDS cases, so most of these questions still remain arguably unanswered. And with that, I will hand over to Cameron.
Thank you, Bart. For the commercial section, we had the privilege of inviting AG, so we could hear from the in-house perspective. But for the ISD matter, for this subsection, both Arnold and Porter and Covington represent both states and investors in any of these cases. So just as a disclaimer, whatever we discuss here is not the views of our own firms, and whatever we discuss about the cases are all the information known in the public domain that I just wanted to make sure because if you type in all those cases, you can see Covington is representing so and so, and Albany Porter representing so many other states. I just wanted to make that sure. I just wanted to give you like a snapshot of where we stand in terms of investment arbitration to show you some statistics and how to see the landscape, the emerging landscape of investment arbitration. Yes, so we do have a slide on the screen. This is an exit statistics from 1966 to 2002. Those of you who are familiar in the investment arbitration field, exit is the International Center for Resolution of disputes between international investors and states, right? This is an organization funded and which is a part of the World Bank Group, headquartered in Washington, D.C., and it's sort of one of the most frequently used arbitration forum for the investment arbitration. So for the because we have limited amount of time, we'll only focus on the exit cases, but this does not capture all the investment arbitration cases out there because there are also the cases under UNCITRAL rules administered by PCA, and also some of the cases use ICC, SEC rules, and other arbitral sort of commercial arbitration institutions. So in the exit statistics, so since the establishment of exit in 1966 to 2002, so over the course of 56 years, I have looked into the data for the information and communication sector. So that's 1, 2, 3, 4, 5, 6, 7, the seventh from the top down. And information and communication economic sector that captures the cases arising from telecommunication sector, which is one of the hotly industry, the tech industry where we see a lot of investment cases arising at the moment. So over the course of 56 years, there have been around 900 cases so far, and only 7% of those 900 cases arose from information and communication sector. But what is not captured here is some of the cases related to the media services. Media is also it's regarded as the tech industry, and those are captured under the services and trade. But I think in order to do like a comprehensive analysis, one has to look into each and every case and decide whether this falls under the category of tech disputes or not. And Bart and I had this interesting discussion when we were seeing the statistics. We were wondering whether this relates to disputes arising from a tech company or whether the dispute itself has a tech aspect. So I think that kind of distinction should also be made. But just as a snapshot, I just wanted to compare this statistics, the 7% of information and communications, and the next slide, which is an exit statistics of cases only in year 2022. So you see the difference in the percentage of information and communications. So for the year of 2022, there have been about 40 cases so far. And out of those 40 cases, 12% arose from the information and communications sector. So you now see that the percentage of cases arising from the information and communication sector has risen. And there's a trend of more and more cases coming out of this tech-related industry. Next slide, please. Yes. So I have gone through 7 most recent cases that have been registered with exit from 2018 to 2022. Over the course of 3 to 4 years, we see that many cases arise from the telecommunications sector. So here, the cases are ordered in a chronological order. So you see the procedural details, the registration date. I have mentioned the registration date there so that you can see when the case has started. All of the cases are pending, except for Uber versus Colombia, only the notice of dispute. So under the investment arbitration, if you go to the investment treaty, you first have to file the notice of dispute, and usually you have this cooling off period, right? Sometimes 6 months, 9 months, and then after the passage of that period during which you have the negotiation, you can file the request for arbitration. So except for Uber versus Colombia, where only the notice of dispute has been filed, for all the 7 cases, all of these are still pending before the exit. So we do not have the award. we don't have sort of the insight into the award, and we only know what's been stated by the claimant. So the first one is Telefonica versus Colombia. Well, I'll just show you first and the second slide. The subject matter of the dispute. So when you go through the first row, you can see the first one is related to the telecommunication services. Uber, well, everybody knows what Uber is. Even in Korea, we're using Uber, which is related to another, there's been a lot of discussions about Uber, whether it's legal in Korea or not. But anyways, except for Uber here, which is the transportation services app, New Star is also related to telecommunications concession. The fourth one, telecommunications, also concession. If you go to the next slide, telecommunication license agreement. Digicel versus Papua New Guinea, that's telecommunication enterprise. And the last one is also the telecommunication enterprise. So out of these 7 cases, 6 are related to the telecommunications sector. I'm quite mindful of the time. I wanted to discuss all the details of the cases, but I'll just show you the chart here. So here, do you see some of the commonalities in these cases as with regard to the respondent? Any common names appearing as a respondent state? Colombia, yes. So Colombia, first, second, and third, Colombia are named as a respondent. The last one, Mexico. I wouldn't blame Colombia, but I'm sure there are a lot of political reasons why we have been sued. The fifth one, Paris versus Sweden. The sixth one, Papua New Guinea, and the last one, Saudi Arabia. Obviously, investment arbitration, in the investment arbitration field, it's the state measures that triggers the claims. So, and in most cases, those are all related to the political change in the government. So, and there has been a lot of political changes in Latin America that has brought investors to start an investment arbitration against those states. I will leave out the Huawei versus Sweden matter, where Art will be delving into as he's representing one of the parties there. So why do we see, so what's the reason behind this new trends in investment arbitration for tech disputes? We have witnessed that 6 out of 7 cases arise from the telecommunications sector. Why is that so? I think it's because, well, telecommunications industry is also one of the sort of, increasing in size, and which also leads into more, large-scale foreign investment out of states, and also the flow of tech development. It's from the developed countries to the developing countries, right? And which also requires a lot of long-term investment. And when an investment period is long, there's a risk of a lot of political changes happening in that foreign states, and you are exposed to that risk oftentimes. And I think most importantly, telecommunications sector is one of the most regulated sector in our daily lives. Obviously, the reasons range from, because of the fact that the telecommunications is related to our personal privacy issues, and also, states confidentiality issues, and also national security issues. And as a citizen, I think, well, yeah, you've got to regulate this. I don't want all my private information to be shared with other, like companies. That's also one of the biggest issues that we need to think about. But as a state, because they are bound by the investment treaty obligations, they do have some boundaries that they have to abide by when they put their regulatory measures in force. And national security is one of the issues that comes up all often, and I will hand over to Bart to discuss more about the national security defense.
Thank you, Camilla. I'm conscious of time, and I'm sure Una will be looking to us to finish soon, at least the main part of the presentation. But the topic of this session today is novel issues in technology-related international arbitration, I think is the title. So we wanted to highlight a couple of novel issues, or at least certainly one, which is national security. As technology becomes more prevalent and as it affects our lives more and more, it has been the subject of also more and more regulation, including on grounds of national security. So states have been taking measures to address some concerns around national security aspects of technology. And this is a fairly, as I said, novel area of discussion in investment arbitration. One case where this issue has arisen is this case, Kyoga mentioned, Huawei against Sweden, in which I'm involved as counsel for Sweden. The case is still pending, so I'm not going to say absolutely anything confidential, but just wanted to briefly mention it as a by way of illustrating how national security issues can come up in these cases. So in that case, Huawei, the Chinese telecoms company, is challenging Sweden's decision to essentially, oversimplifying, but essentially exclude Huawei from Sweden's 5G network on national security grounds. And I wanted to read out a brief excerpt from the request for arbitration that Huawei filed in that case. This is obviously a public document. So Huawei there said the following: the alleged policy reason for the PTS decision, and that's the decision, the PTS decision is the decision by which the Swedish telecoms regulator excluded Huawei from the 5G network. So the alleged policy reason, i.e. national security concerns, this is according to Huawei, is absent elaboration and substantiation, not a legitimate or rational policy basis for that decision, given that such concerns are solely based on an arbitrary and as yet unparticularized assessment by the Swedish security police and the armed forces. So a detail that I forgot to mention is that the Swedish telecoms regulator decided to ban Huawei essentially following the opinions of the Swedish, essentially the secret services, which again opined that for national security reasons it was necessary to exclude Huawei. And so as you can see, I think this is an interesting example of a case, an investment arbitration, where a state is accused of breaching its state treaty obligations due to a measure taken on the basis of national security reasons. So that's a very new development. There have not been many cases where this issue has arisen. One case that I did want to very briefly touch on is a case called Divas against India, which had to do with satellite technology and the licensing of satellite spectrum capacity. And there the tribunal had to grapple with a similar issue. There the treaty contained what is called an essential security clause, which provided that essentially the provisions of the treaty would not limit the right of India in this case to quote, apply prohibitions or restrictions of any kind or take any other action which is directed to the protection of its essential security interests. And so in the arbitration, India said, essentially argued, well, we have this provision in the treaty, and this measure that we took, which was to exclude the investor from the satellite capacity spectrum, that was done on national security reasons. And the tribunal had to grapple with that. As you can see on the slide there, I won't read it out, but the tribunal did make the point that national security issues should not be essentially adjudicated, and certainly a deference should be accorded to the state. I'm not going to go into more detail, but I think it's interesting to see tribunals recognize that national security issues are in some ways special. And then on the following slide, just very briefly, I wanted to mention some damages-related issues that may arise in these cases. Yeji, in her presentation, talked about how in commercial arbitration, compared, for example, to Korean litigation. I understand, the damages awarded can seem quite generous, but in investment treaty arbitration, in some ways, companies, and especially technology companies, may potentially find that they're not able to recover as much in damages as perhaps they would like to. So I listed here 3 different types of valuation approaches. The first one, I think, most commonly used based on the income, the company's predicted income. As I said, it's frequently used, but it is only suitable where a company can, so the claimant can point to reliable forecasts of its future profits. So, but for the state's measure how much the future income would have been. And for technology companies, it seems to me that often could be challenging, especially if it's an early stage investment, or if it's an investment in a very new and emerging technology where it's quite difficult to predict what the future profits could be. Then the second approach, which is the market approach, involves looking at the company's annual income and then multiplying it based on what the market uses, the multiplier that the market uses for publicly traded companies. But again, the difficulty there is that often there will not be publicly listed companies that have a similar profile, so it won't be necessarily easy to determine the value of the company on that basis. And then thirdly, the net asset approach involves looking at the assets of the company and valuing those. But there, I think the investor may consider that approach is unjust in a sense because it only looks at its assets. It doesn't take account of its ability to generate profits. So, those are some of the challenges that technology companies may potentially face in industry arbitration in terms of recovering their damages. And then we wanted to briefly close off this part of the session with some practical tips, and for that I think I'll hand over to
I'll briefly sum up in 30 seconds. Yeah, started. Right, so for investment arbitration, as Bart had discussed, you need to be a qualified investor and you need to have a qualified investment under the investment treaty. So before making any investment in a foreign state, we advise the clients, the companies, to see what kind of investment treaties you can make use of, through which treaty you will be most beneficial. So that's one of the most important factors to consider at the pre-investment phase. And which is the second point is also related to the first point under the post-investment phase, is that you need to have legitimate expectation to rely on at a later stage. So you have to, gather evidence of state's actions and inactions, and if you can, please to get specific assurances. And also, if something comes up, if you have some disputes, call your lawyer, seek advice from, arbitration specialist.
I agree with all of that. I'll just be very brief. I will say that call your lawyer, but also call your an arbitration specialist, and especially industry specialist. And I say this because it is, as I said, a niche area, and it is good to have someone familiar with industry arbitration look at your dispute, and do so ideally early in the disputes, which can help. And then finally, obviously, the advantage of arbitration is that you have an influence over who's on the tribunal. So take advantage of that. Do contact your arbitrator, research, and consider appointing arbitrator who have familiarity with technology-related issues. And with that, we'll hand over back to you.
Great. Thank you very much, Bart and Helma. I think that was a short but a very helpful summary of the increase and the changing landscape in treaty-based claims. So we thank both of you as well as our panel. And they have been very thoughtful and left me 5 minutes to take questions from the audience. So there you go. I'm thinking of you, but let's just take the one from the
Just a quick thank you to the panel and the moderator for a very interesting session. I'm a U.S. patent attorney working in Korea 20 years now, but regarding patent disputes, there's a reluctance to go to arbitration because of lack of arbitrators who have technical expertise. What are your experiences from that? Just as a disclaimer, I have a personal kind of agenda because I would love to join an arbitration board. I have expertise in telecom standards, actually, but my colleagues and I, we've been frustrated to find arbitrators with deep technical knowledge. What's been your experience? Maybe your experience has been good regarding arbitrators, but just interested to hear from the panel regarding this issue.
Before they start, I think you should go around and meet people at this conference and get potential opportunity.
That was my suggestion. You stole my thunder. But no, you're absolutely right, and it's a very good point that you're raising. I can only speak for Korea, and I do know that other arbitration institutes, for example, I think CI has a special panel of arbitrators. I can't speak for all of them, but who have good IP backgrounds. But again, that does not necessarily mean that IP background translates into technological knowledge in the vast areas that are being discussed. It is actually a point that is being discussed here in Korea also, that KCAB, I don't know, nobody's here from KCAB, which is good. That KCAB should also try to promote such an effort to revitalize IP-related arbitrations, because they are declining, case-wise and KCAB. So yes, personally, to be quite frank, I did not have that issue yet, but it was because the disputes I was involved, the technological issues were covered by outside external experts, and the tribunal was basically more on the legal side, so they were not tech experts in the cases that I was involved, but maybe my colleagues.
Sorry,
Okay.
considering your time, we'll have to pass on to the next question. But just one point I wanted to add. The arbitral institutions, they actually are the best resource for potential arbitral with different backgrounds. You can call them actually. And before you start a case, and get a list of names who are good in technology. They're willing to help with that kind of stuff. Next question, please.
My name is Yoshita Katori, the arbitrator. And my question related to the expertise issue, but I'm a member of the recent Armstrong efforts to prepare the possible guideline or protocol, especially for the high technology distributed, because the lifetime of the such high technology like the 5G or AI would be very short. Even if you can resolve it in 6 months, that could be too late. Then my suggestion could be some, the kind of civil law type of evaluative type of mediation combined with the arbitration, something could be helpful. So I'd like to hear from the Korean colleague. Thank you very much for your discussion. Anyway, from Japan and Korea, that kind of combination of sort of a civil law type of quick evaluative could be including like expert examination type of process. Should be quite helpful for such answer report. So I'd like to hear your kind of thoughts, especially from the Korea's kind of civil law culture type of ideas.
Maybe Kyung-hwa, you want to take the question?
Thank you so much for this interesting question. I have great interest in mediation, although I have, spent all of my life in arbitration and litigation. Well, speaking about Korean companies, there's a growing interest in mediation. Also, it's not only because of the fact that Singapore Mediation Convention has come into effect. Korea has not yet ratified the sign on the day when it was open for the signature. What we see right now is, as Yeji has pointed out, litigation in Korea is very efficient. It's cheap. It's really time efficient as well. You take maybe 1 year to finish in the first instance where we don't have discovery. It's really done very efficiently. The courts work very hard to really rule out their judgments. So, as an arbitration practitioner, it was really difficult to sell arbitration to the Korean companies. And after going through some stages of experiences with arbitration, now the demand is coming from the Korean companies to start mediation. So it was not our suggestion to the clients, but they want to try something different to complete the resolution of dispute at a very, very early stage. And as Sensei has rightly pointed out, they want to seek evaluative mediation. They ask us to appoint a mediator with great expertise in that particular subject matter, so that the mediator could give some evaluative views to sort of narrow down the differences between the parties. I think that's sort of where the dispute ADR scene is moving into, but also there are some very litigious Korean companies who want to fight up to the end to get that award. So we'll see how the mediation field goes. But there's a very growing interest in Korea, absolutely.
Thank you very much.
Next question, please.
So questions for YJ and PhD. Congratulations, by the way. I'm very glad that we made one in the arbitration. I don't know, forgive me if you have explained what the governing law was, whether the benefits of arbitration as opposed to traditional litigation was because it was a dispute between a Korean company and a Chinese company concerning that particular technology, or because it was concerning China. Because a lot of the attributes that you pointed out is pretty unique to China. Well, that's maybe one thing that I would throw out there. Maybe to Yeti, if you had lost that case, if you had, that is hypothetically, would you still advise your own company for all of your arguments? Because I agree with my colleague asked earlier. I've done patent litigation and also arbitration involving technology. I personally much feel safer with litigation, traditional litigation, particularly if it's a U.S. litigation, because they're just, I don't want to put words in your mouth, but I still wonder whether you feel that arbitration seems to be a overall unity solution for the country.
Yeah, I wouldn't say, if we had lost, so I got my start, so. If we had lost the case, I think I would still, my team would have still recommended arbitration, but we would not consider it as a universal solution to everything. First, because our main reasoning is, of course, like what you said, it had its particular aspect because it was against Chinese company. But at the same time, we wanted to have this finalized in one proceeding. So we didn't want to have it to be appealed because we could easily suspect that the Chinese company would do whatever it takes to actually lengthen the time of the proceeding because they were earning so much money even during the process. So that was our main reason. However, the case that we wanted is still in a set-aside stage. So that was kind of disillusioning moment for our company. But since it's not heard on merits, we are still hoping that we could get it as fast as possible. And secondly, we also experienced that there are expedited procedures. We also used interns, and we also heard from or advice from our consuls that there are procedures as summary judgments. And the most important issue for us was that so this had to end fast, and that we needed to have our case heard in front of the tribunal to the full extent, so that they understand that this is a big damage for us. Because in Korean courts, if it didn't really happen, what damage did you actually have? All your revenues are just hypothetical. But we wanted to explain to our tribunal that's not the case in these tech disputes, because
they are becoming humongous companies out of our own intellectual property. So, yes, so to answer your, sorry, so long, but to answer your question, yes, I think we would have recommended arbitration, and even though if we had social falls during the proceedings, the remain has actually proceeded like 4 arbitrations along the way because of that trace.
I also have a question for Bart. I think the biggest hurdle, one of the biggest hurdles is the jurisdictional requirements in order to raise an investor state claim. So I'm not sure if the 7 cases that Kang-Hwa went through, whether they all went and prevailed on the jurisdictional issues yet, but I'm wondering what your views are on how these technology claims will really fare under these jurisdictional challenges.
Thank you.
So I think most of those cases, I believe, are still pending. So I'm not sure if what the kind of status is with respect to jurisdictional issues. But and obviously, I can't comment on each of those cases in terms of how they will fare on jurisdiction. But I will say that some of the issues that I raised on this slide are probably not going to arise in every single technology case. I mean, it's this last point there about the digital business. That will be true of some companies. We talked with a panel yesterday during the conference about the metaverse and how companies operating within the metaverse can be involved in disputes. Well, in that case, indeed, it may be somewhat difficult for a company to demonstrate that it made an investment in a particular state. But for many technology companies, that will be a more straightforward issue. The company will have set up a subsidiary in the relevant state, will have perhaps acquired assets. So some of these issues, admittedly, are somewhat theoretical and novel, and I think that they will come up in some cases. For example, and I'll just be brief here, but the case involving Uber against Colombia, which hasn't materialized, there in the notice of dispute, Uber was describing its investment and was talking about a digital platform that it set up and made available to riders and drivers in Colombia. And I don't know the details, but if the investments comprise just the setting up of a platform and making it available to individuals in Colombia, well, arguably that could mean that there wasn't an investment in Colombia. I'm speculating that that's a possibility. So I think these are interesting questions, or at least I think they're interesting, but they may not arise in every case.
Great, thank you. Now, I'm willing to stay here until they kick us out, so if anyone has any further questions, let us know. There you go.
What is very important? In the communities, we mentioned national review is not really exceptional reason that the arbitration not immediately apply high standard or they reject. Because national review seems to be often cited reason for restrictions in foreign investment or restrictions in export these days. Frequently referred to. So in that case, which forum the company should seek, because that can be reflected in this kind of arbitration. What would be the right forum?
Well, since I represent Sweden, I don't think I'd like to say what Huawei should be doing, but I will say that this is, I agree with you, that this is an emerging, I think, trend that companies operating internationally are finding themselves in situations where states are taking measures for national security reasons. It's not a secret that many states are taking measures relating to China, Chinese investors, Russian investors, and so I do think that this is in fact why it was interesting to include this in our presentation. Is I think national security will become increasingly a kind of prominent issue in industry cases. In terms of what the solution is for companies affected by that, I don't know. It may be matter of just geopolitics, and I think for example, Chinese companies may find themselves increasingly affected by these measures. I would say as, counsel to a state in a case like this that, investment treaty arbitration is not as suitable for resolving those disputes, but it's someone to say, exactly what the solution is. Other than, we mentioned earlier the idea of seeking specific assurances from a state. That is one option where where a company investing in a foreign state where it thinks that it may be affected by future measures can seek specific assurances, and then we'll have additional protection, I guess. I realize that I probably haven't answered your question, but it's a tricky question for me to.
That's okay, Bart. We'll ask it to you next year after the case is over. Alright, so I think we've all enjoyed and the panel discussion today. Thank you for being very active, and thank you for the panel, definitely. And we encourage you to stay and get their business cards, talk to them, introduce yourself, and ask your private questions, and enjoy the rest of your time at the conference. Thank you for coming, everyone.